How can you prepare your child for an upcoming child custody hearing? Well, my name is Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan, and today we're going to continue our video series designed to educate and inform the public, so please subscribe to our channel. How you can prepare your child for custody hearing is very, very tricky. You see, on the one hand, you want your child to know that there's a hearing coming up. You want them to know that there will be testimony, that the court might ask questions, including asking the questions of the child. One of the things you might do is if your child is, let's say, 12 or older, you might tell your child that the court is going to ask you questions about your preference. Do you want to live with mom or do you want to live with dad? Now, what you should probably do, if that's going to happen, is tell your child that the court is going to make that inquiry, that it's up to the child to express a preference, that the court can ask the child questions, that the child can ask the court, can I speak to you privately about these issues? And, the court will do an in-camera interview of the child, go on the record, but in chambers, so that the court can take it into account. And the court will set up a record, and the court will say something like, we are going to take some testimony from the child, and I will come back on the record after having done so. And then it's all done privately, and the court will come back on the record. The court will say, I've had an opportunity to talk to the minor child privately. The minor child has spoken to me about preferences one way or another. I'm not going to indicate whether the child expressed a preference. I will simply say that the court did discuss matters with the child and that those will be taken into account. And that's it. This is done this way so that no parent will be able to find out whether or not the child said, I want mom, I want dad. The child won't be burdened by having to make a choice and make that known to the other parent. Nobody wants anybody to feel bad about it. So that's how it goes. And you can prepare your child for the hearing by telling the child that you have that right to speak to the court privately about any such issues. You should not prep your child about what to say, because what's going to happen is the first thing that's going to come out is if the child is giving testimony, the court's going to say, has anybody told you what to say to me? And the moment the court gets a sense that one parent is trying to influence that, that's the moment when you begin to lose your case. Because at that point, the court is going to feel that's a remarkably poor judgment on your part to try and influence the child in that way. And number two, the court's going to not be able to really rely on what the child says because it's unduly influenced by a parent who's maybe, offering the child, I'll give you a car when you're 16 if you're living with me. If not, I can't, that kind of thing. So you've got to avoid that. Now, clearly, the child's testimony could be important in a child custody proceeding, and whether or not your child should even participate or to what degree becomes an issue. Now, obviously, if there's a history of abuse, especially directed at the child, these are things the court has to know about. So in that case, the child might well have to share that with the court. But on other issues where there is an abuse, where it's not so simple, where it's maybe a close call, the court may very well want to hear from the child. And you want to make sure that your child's not giving testimony that will be, rebutted as tainted. So therefore, you've got to be careful about this. Now, if you have any questions about your case, of course, reach out. We'll be glad to help you out.